And senators would say to you, the bill does what?
Right. Right.
In that context, by the way, it just occurred to me to ask, while the big, beautiful or ugly bill, depending on your perspective, is being debated, do you have anything to say about the fact that it's a multi-hundred-page bill that nobody will have read, including the members who are voting on it?
Oh, it's amazing. I mean, the House Republicans expressed shock and dismay that there were things in the bill that they didn't know were in the bill, that they only figured out afterwards. And the senators, as far as I can tell, not only haven't they read it, I mean, as they were doing votorama, which, is this last part of the process for reconciliation, where there are a series of amendments and the floor votes are kept open and there are, all kinds of goes through the night, all of that mishigash. While that was all taking place, the amendments weren't even all printed. I mean, some of them were just like handwritten and being handed up to the chair. So there's literally no chance that they could have read all this.
Yeah. So that's a little nuts. Let's mention something else that's nuts. And it's an issue that relates to you in certain ways and me as well. These executive orders imposed on law firms, my law firm being one of them.
You're at Wilmer Hale.
I'm at Wilmer Hale. You were at Perkins Coie.
Yep.
And I've heard you talk about this before. Stinging rebuke and loss on the part of the administration with respect to all four law firms, all of whom received TROs and preliminary injunctions. There was a period of time in which the government had to file a notice of appeal. The first decision they could have appealed was the one against your former firm, Perkins Coie. The days were ticking by, and it almost looked like the president had moved on, and then they filed a notice of appeal yesterday. Do you have a reaction to that?
Look, I think that, first of all, I was surprised that they filed a notice of appeal because they're going to now lose in the D.C. Circuit. And it struck me that they would rather not have losses at the Court of Appeals level. They'd just eat the losses at the trial court. But, on the other hand, I'm not surprised because their litigation decisions don't seem to be making any sense. I mean, you know this better than anyone. The great advantage that government lawyers have, whether you're a former prosecutor, whether you are, a line lawyer in the civil division, whatever it is, the great advantage you have is that when you walk into a courtroom, a federal courtroom, as representing the United States, representing the Department of Justice, you normally walk in with an incredible amount of, a lot of goodwill with the judges and a lot of credibility with the judges. And what's just remarkable is how much they have squandered that. I mean, they squandered it sort of in these law firm cases that you mentioned. They've squandered it in some of the a lot of the Doge cases and the firing cases. I'd argue they squandered it in the Adams case in New York, where you had a series of high profile resignations over it. And so in some sense, nothing surprises me that they do.
So you expect that the four cases will be consolidated and there will be one panel in the DC Circuit that will deal with these law firm executive orders and that they will lose resoundingly?
If they appeal all four, I do think they'll be consolidated. At least
do you think they pick and choose? Why wouldn't they? Because obviously we're waiting with bated breath to see what happens. What would be the logic of appealing some but not others?
So there isn't any logic to there. Look, there isn't any logic.
That's often the case.
Like, this is the thing. There's no logic to the four law firms they picked. I mean, let's just start with that. I mean, they picked Perkins Coie because I had once been a partner there.
Yeah. Do you think they didn't update? You think they had an old Google search and they forgot that you left?
I have heard that theory. But then they targeted your firm because Bob Mueller had been there. They'd
been there. Yeah.
Yeah. They targeted Jenner because Wilmer had been there. The story that I think is the most interesting, I mean, they're all, it's all terrible, but the story that's most interesting is they targeted Sussman, I think mostly because they had won a settlement against Fox News.
Yeah. Yeah. And then look, there are other law firms I won't mention.
Oh, I will. I've got lots to say about it. You won't. I will.
I would get in trouble to mention that have not gotten in trouble, and then others who have settled. Politeness prevents me from saying anything about them at this moment.
I'm not polite.
Okay. Well,
I've written about Paul Weiss.
I know you have.
In fact, so many times that people occasionally ask, like, why are you obsessed with Paul Weiss? And I say, I'm obsessed with Paul Weiss for two reasons. The first is because of its unique place in the legal market, which you probably could speak to. It was a famed law firm, Judge Rifkin's law firm, and a firm that was the first law firm that had Jews and non-Jews practicing together in the city of New York. It has a lot of former Democratic officials and office holders who have been associated with it. And so its decision to capitulate, I think, did more damage than it would have been if it was like Kirkland and Ellis, another firm that, by the way, did capitulate. But the second thing is it was obviously the first. And in doing that, it put all of the rest of the large law firms, I think, in a bad spot. So there, you didn't have to say anything. You could just like look at the camera blankly while I said that.
Looking at the camera blankly.
Yeah.
Could you talk about the Supreme Court?
Yeah, just before we leave the law firm thing, because
sure.
I got one more law firm thing for you.
Please.
So the thing I do find curious is that he has stopped targeting law firms.
Yeah.
And
well, has he stopped? Maybe
that's the question. This is what I was going to ask you. Why do you think he went as far as he did, as fast as he did, and now we don't see,
Well,
more?
One theory was he sort of won, right? He got to get up to, he believes in metrics and milestones. And I think he reached, by his own calculation, the milestone of $1 billion in pledged pro bono. He very gleefully could joyfully talk about the capitulation and the bending of the knee of multiple law firms. And he's got other stuff going on. And at the same time that he was, losing unceremoniously in court, as we mentioned, time after time after time, and sort of increasingly stinging opinions by respected district court judges in D.C. Why do more? That's the theory. Do you think that has any weight?
Yeah, I do. I also wonder if it's gotten harder to get firms to capitulate. There was kind of like the first firms.
Well, one would hope.
I think in the first firms, the conventional wisdom was that the moral thing to do would be to fight, but the smart business thing would be to capitulate, and that those were in tension. And I do wonder if it's actually turned out not to be the case, that actually the smart business thing also was the fight. But I wanted to ask you also about universities, and whether you think, we then obviously we saw him target media companies, we saw him target law firms. He's obviously targeting universities, including in New York City. You still live in New York City, right?
I live outside the city.
Okay,
but I work in the city.
Yeah, so you are familiar with the targeting of Columbia, obviously in New York,
well, also in Harvard.
And Harvard, right? Your alma mater.
So in the same season, the place where I earn my livelihood and the place that where I earn my education, both under attack by this president. Look, I'm glad that Harvard's fighting back as well. There is some rumbling about trying to find some deal. I think a university stands in a slightly different position from a law firm. Maybe not as strong a position. Private university, and I think that we'll see what happens. I don't know the ins and outs of what a deal might look like. They can't offer pro bono, so I don't know. I'm not involved in that litigation, so I don't know.
Yeah, me neither. I was just curious your perspective on, sort of the same question. Do you think he's done? Like, do you think it's like I go after Harvard and I pick this big fight with Harvard?
I think there are people
like, because like Yale is sitting right there out in New Haven. You're right, exactly. You're right. Yeah.
No, and I think no. This is all speculation.
Of course.
The president goes after shiny objects, and maybe in his assessment, Harvard is a shinier object than Yale. And for once, maybe the friendly rivalry is such that the Yale folks appreciate that the shinier object is Harvard. I don't think they've appreciated that in the past. And they have a very earnest football game in November of every year. But there's not, as you said earlier, there's not a lot of rhyme or reason to any of these things. There's not a lot of logic to them. And, the only thing he understands is, as a fighter for all these causes, over the years is that he needs to get punched back. Otherwise, so as I go back to thinking about your original question, I think stinging defeats and getting his clock cleaned, at least his advisor must understand, there's not necessarily anything to be further gained by adding law firms. But you never know.
Yeah.
Like, he reserves the right at any moment to do it to any law firm, and he probably doesn't want to take it off the table in the same way he doesn't take tariffs off the table or anything else off the table, even when he retreats, even though he has been dubbed the taco president, right?
Yeah. All right. I got one
chickens out.
I got one other question I got to ask you about New York, which is your former workplace. So you displayed enormous courage. I mean, at this point, it's like so long ago, people forget, but you displayed enormous courage when you were the U.S. Attorney of the Southern District of New York, which is, for people who don't know, the federal prosecutors that oversee Lower Manhattan or oversee Manhattan, most prestigious office in the country, famed office, very aggressive. And Preet, you ran it. And you displayed enormous courage in the first Trump administration in the way in which you refused to capitulate to Donald Trump. He ultimately fired you. And that was, a story of the first Trump administration of really principled leadership. I have to say, I don't know, and I'm embarrassed to say I don't remember the name of the woman who was the acting U.S. attorney, who resigned. Yes, Danielle Sassoon. You had her resign over the Eric Adams matter. You also had, I think, a line assistant, although you may tell me he was more senior than that.
Perkins Coie.
Yeah, right. Exactly. Him resign. In fact, I do a weekly newsletter for Democracy Docket, in which I have a section called "The Fools and Cowards of the Week," which is like a quote, literally from his resignation letter.
From the letter, yeah.
Yeah. And I'm not going to ask you, although I'd be interested if you have something to add about the two of them individually. But the thing that is interesting is it's a lot of principled action for one U.S. attorney's office. Is there anything broader to be drawn there from the way that all of you across, because I gather their ideologies is very different than yours. The impression I get from a distance is that, they're conservative, conservatives, and you're obviously not. But is there something to be drawn from the fact that all of you were in that same office?
Well, I can't say it's in the water because we didn't have potable water because we were a decrepit, government, old, aging, dilapidated old government building. I'd like to say that we screened well. I mean, I hired both of them.
Oh, is that right?
I also hired Emil Bovee, and people can draw whatever.
Okay, well, now you've just now all of a sudden people are leaving. Like, look at other people are like, I can't believe it.
Nobody bats 1,000 in baseball or otherwise. But we did take great care to do two things. One, never care about, give any weight to someone's political affiliation or leaning or ideological affiliation or leaning. I had no idea who was from what party or how they voted. And sometimes you find that out later when someone who runs for office, this sometimes happens, or gets nominated by a Republican president rather than a Democratic president for a judgeship or something like that. But it was a no politics zone. And that mostly, at the end of the day, we were so lucky and had the luxury of having so many fine resumes from really amazing lawyers, like the best lawyers in the country. You could be an amazing credential lawyer and not get the job. And the reason for that was that, especially by the time they got to the last round, and again, mistakes are made, but by the time they get to the last round, you know that the person who's been vetted upside down, backwards and forwards, is a credentialed, smart lawyer, can write a brief, can argue, is very smart, but we don't know if they're wise. And we don't know if they have good judgment. And particularly in the criminal division, where you have lots of young people, no matter how smart they are, whose decisions, many of which are not overseen closely because there's no time for that, because their dockets are so expansive. They have so much ability and authority to affect adversely individual human beings' lives and livelihoods. But the most important quality is judgment, character, and wisdom. And if you pay a lot of attention to that, again, it's never perfect. you pay a lot of attention to that. And if you have a doubt about somebody's ethics or morals or judgment, as I said again and again, you don't hire that person. I often tell the story. I would ask the question in the final round when people applied to be in that office in the criminal division, how would you feel about the fact that by definition, if you do your job properly, that you as an applicant, then as an assistant U.S. attorney, will be the proximate cause for sending people to prison for large portions of their life? Which is a heavy question, but an obvious question. And every once in a while, you get somebody who thinks that the right answer is, or maybe they believed in the answer, that I'd have no problem with that. And they answer so quickly and spiritedly that, they deserve it. They go to prison. That's the way it is. And people are surprised to learn that we don't hire those guys because they have indicated a lack of appreciation and respect for the thing that we're doing there, which is not to sort of crassly and aggressively put people in prison. That's a consequence of what you do, but to deliberately, carefully, and justly do what's right. And that's the only job. And every once in a while, you see there's a person who has a cowboy orientation towards, doing things hastily and punishing people. The impetus should not be to punish people or celebrate their punishment. The impetus should be to make sure that justice is done. And those are different things. And hopefully, there's a through line there. Not in every case, but in most cases, I like to think that's true.
Yeah, well, it's really it is a testament. By the way, it's a testament to the office and the culture of hiring. It's also, like I said, I don't know any of these folks, but from what I read, all three of them are Republicans and conservatives, and the fact that you hired them is just further proof that you did not apply any political litmus test. So let's talk about the Supreme Court.
Yeah. So this whole business about the no nationwide injunctions. A lot of people talked about the legality of it, the constitutionality of it, the back and forth between Justice Amy Coney Barrett and Justice Jackson, and all. But I want to ask you, given what you do, that you're sort of boots on the ground, how's that going to affect your practice and what you do to vindicate people's voting rights and other things along those lines? How's it going to affect you?
Yeah, I mean, I think the truth is we don't know. And I think there have been a lot of people who have jumped to conclusions. On the one hand, I'm going to have three hands. On the one hand, you have Justice Barrett's opinion, which is an opinion of 6 justices. And I think that the result, her desire to have a broad, albeit without any of the more liberal justices, but to have the entire range of conservative justices on one opinion without it being fractured, I think meant that she elided past several really important questions. And you actually see those questions then raised in the concurrences by, on the one hand, Justice Thomas and Alito, and on the other hand, by Justice Kavanaugh. And, Justice Alito basically says, this opinion's good as far as it goes, but if we allow third-party standing and we allow class actions and, we don't do something about the APA, I think he threw in, then this really won't have any bite. And at the other side, you have Justice Kavanaugh writing for himself, not joined by anyone else, saying, well, yeah, this applies to the lower courts, but of course it doesn't apply to the Supreme Court. We can still, through our docket, essentially enforce the equivalent of universal injunctions.
Does that give you comfort? Does that give you comfort?
Well, so what I've told folks is it doesn't give me comfort because it was not signed by any other justice. So that is great. that is great. That is what Justice Kavanaugh believes the line will be. But I suspect that most of the justices don't know where they want the line to be. I mean, I think Justice Alito knows where he wants the line to be, and Justice Thomas knows where is the line to be. I don't think the chief really knows where he wants the line to be, and I don't think I don't think that Justice Barrett does. And of course, the more liberal justices are going to have to make a tactical decision in light of this decision where they think the line is, right? So I think that this is one of those things that is a little bit right now of wish casting from all sides, or fear casting in some cases from all sides. And it leaves open a lot of questions about how this actually works. So I'll give you one that is in the voting arena that is very, like, I don't think anyone knows the answer. So if you can't have a universal injunction, which means a judge can only grant an injunction necessary for the scope of relief necessary to give the plaintiffs full relief. Okay, that's essentially what Justice Barrett said. What does that mean if we bring a lawsuit on behalf of, for example, the Democratic Party to vindicate the right of Democratic voters to, I don't know, use drop boxes? Does that mean that the complete relief would just be that only Democrats can use drop boxes? Or does it mean that actually...
Well, that's what it sounds like.
Right. Or does it mean that you need essentially a full injunction, right? Because there are other principles that come into play when you start to parse relief this way. What does it mean for equal protection law if you're not giving full relief to everybody? And so I don't think we know the answer to that. I think what we do know is that in cases where the stakes are high for individuals, but not for groups of individuals, this is a calamity for democracy. And obviously birthright citizenship is a good example of that, right? Where the stakes for any one person are very, very high. But if you make them all have to go to court individually, the cumulative effect is very, very bad.
So Justice Barrett and others have suggested, well, there's still an option. There's something called a class action suit. Are you boning up on your class action bona fides?
No joke. I spent some time this weekend, pouring over the class action rules.
I'm going to give you a hint. Rule 23.
Yes, I got that. But again, this is where I don't think we know, because she points to class actions as one potential solution. She points to the Administrative Procedure Act, which is a technical thing, but maybe offers some relief. But then you have the conservative justices saying, not so fast. Like, we need to crack down on those things. And so I don't know where this lands once you engage all 9 justices on the new, the new floor. Like, where do the liberals go in that?
I want to ask you a question, then we got to go. And it's a question I'm asking everyone I can get my hands on, so to speak. On the podcast this week, Stay Tuned with Preet, which everyone should listen to on Thursday, I have a panel of experts like you on constitutional law to talk about this. And the question I have is, there's this line from Justice Barrett's opinion, and I wonder if you agree with it as a statement of principle or law. And it seems to me to be the heart of the whole case. Federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. Is it correct to say federal courts do not exercise general oversight of the executive branch?
Yes, that is correct.
So if that, okay.
Good.
No, so how does one think about that statement, if you believe it's a correct articulation of constitutional law, with the thing that everyone learns in civics class, that we have a system of checks and balances, and that the 3 branches are co-equal branches of government, and the common understanding that people have, aside from a specific articulation of a principle, that when the executive branch overreaches, there's got to be a check and a balance. Isn't the court that check and balance? How do you square those 2 principles, or is the second principle wrong?
No, I don't think it's wrong. I think the second principle is partially wrong for a slightly different reason. So Jamie Raskin, the congressman from Maryland, pointed out to me, and I always give him credit for this, we don't have 3 co-equal branches of government. As he said, co-equal is not even a word.
It should be equal, right? It's
right.
You don't need.
Exactly. That actually the Constitution envisions that the legislative branch is the most powerful. The framers of the Constitution and the document itself really give Congress most of the power. The powers given to the presidency are actually relatively limited. And the problem we have right now is that you do not have a Congress that is at all interested in exercising its power vis-a-vis the executive branch. So Speaker Johnson and John Thune, the majority leader, have ceded essentially all of their constitutional authority to Donald Trump. I mean, all of it. I mean, and you can go down the list, the tariffs, which you could the war power. I mean, you could go down the list. So that's kind of thing number one. But thing number two, go ahead.
No, go ahead.
But thing number two, with respect to the courts, I think that you can both believe, as I think she's right, that the courts don't operate as kind of a roving ombudsman, searching out waste, fraud, and abuse in the executive branches. They're not Michael Horowitz or the inspector generals, right? They're not there to just kind of like find where they think things have gone, where the executive branch is overreached or Congress is overreached. They do resolve cases and controversies, but that only gets you so far, right? That only gets her so far. And the question is, well, what does it mean to have a case or controversy that the courts should adjudicate, and how do they adjudicate it? And I do think that the dominant theory among legal conservatives and among the U.S. Supreme Court is for a very strong executive, the unitary executive vis-a-vis other subordinate offices in the executive branch, but also a strong executive vis-a-vis the other branches. And so and I think that is really dangerous. I think that is a proposition that that is not built for the realities of our time. I thought you were going to read a slightly different passage in which she says,
"Well, I think I'm gonna. Let me know if I got it."
Yeah,
because the average citizen wonders, when you have equal or co-equal branches of government, if one exceeds its authority, and the countervailing branch, the legislature, sits supine or lies supine, is the judiciary just supposed to sit idly by? And the answer to that, I guess, from Justice Barrett is Justice decrying, complaining about Justice Jackson's position. Says Justice Jackson decries an imperial executive while embracing an imperial judiciary. That's not the passage you thought I was going to read.
That is not the passage I thought you were going to read. There is a passage in which she says essentially that the executive has to follow the law, but there are times where they may not follow the law that the courts can't remedy.
Same idea, but it's the same principle.
Yeah, and
does that seem right? Does that call to mind this the suicide pact?
Yes, I was going to say the Constitution is not a suicide pact, and the problem I have with so much of the jurisprudence of the court today, and of courts more generally today, is that they are Justice Barrett's position makes sense because she mentions the oath of office that justices take, that it exceeds their power. That assumes that Donald Trump is abiding by his oath of office, right? Like in a world in which, and I want you to imagine,
right.
I want you to imagine this, in which every member of Congress that takes an oath to uphold the law and the Constitution, every judge and every president and executive branch officer that takes that oath, that every day before they vote on a bill or before they take an executive action or whatever it is, they ask themselves, am I meeting my oath? And if you had that world, then what Justice Barrett said makes a lot of sense. But we don't have that world. Like, I don't think a single Republican who voted on the reconciliation bill today asked themselves, are each of the provisions in this bill consistent with the Constitution? Are each of them consistent with other federal laws, with Senate rules, whatever it is? I don't think a single one of the Republicans asked themselves that question. I don't think Donald Trump has ever even fathomed the idea of asking them the question, am I doing something that is consistent with my oath to uphold and defend the Constitution? I just don't think that, and to take care of the law.
We have proof of that. Donald Trump was asked a question about whether or not he has to follow the law or uphold the Constitution. They go, I don't know. I have lawyers for that. Even though he took that oath, he has no recollection of the oath or no care for it. Anyway.
All right. Now I have one question for you. Okay, I have one question for you. You got your last question. So I am old enough to remember when I think it was Loretta Lynch was on a plane on a tarmac, and Bill Clinton was the wife of a presidential candidate, Hillary Clinton, And he knew Loretta Lynch, obviously, from from their time together in government. And he paid a visit on the airplane to say hello. Fox News, the right wing echo chamber, treated this as if this was the scandal of the century. And that's because and I think you tell me if I'm wrong. As I recall, Barack Obama only once visited the Department of Justice while he was president. It was to go to Eric Holder's going away party. And that also was criticized as like a breach of protocol. And I'm sure you're going to tell me that when you were U.S. attorney, you stayed away from, partisan or from the political branches. So you got Pam Bondi, like literally, like moved it, like she's on the White House lawn, she's in the Oval Office, sort of yucking it up with Donald Trump. They make no pretenses, as far as I can tell, that there is any separation. I think Bovee actually has sort of suggested that. I think Fondi suggested that. Certainly Donald Trump has. What is your take on that? Not just from a right and wrong, but what is lost? Like I asked Dan Goldman Goldman about this, and I got a really interesting answer. So I wanted to ask you.
Dan Goldman, who I did not hire, but he served with me as well in the U.S. Attorney's Office. I think it's disastrous. And it exposes a lot of hypocrisy on a particular side of the ideological aisle. I mean, you gave a couple of examples. Arguably, they pale in comparison to the fact that the sitting president of the United States, Donald Trump, in his first term, held his freaking Republican National Convention on the premises of the White House. Like literally the most political thing you can do, the most partisan thing you can do as a political party is to hold your quadrennial convention. He did it on White House grounds. There's something called the Hatch Act, which is very quaint, that we abided by and were required to abide by scrupulously and very carefully under penalty of losing your job. Doing anything at all in your official capacity or from your office or under the umbrella of being a Justice Department official was complete anathema, and everybody knew and understood that. So I think part of the problem is you define deviancy down because, who has the time and energy and inclination to bemoan things like, a press secretary talking about politics from the podium of the White House when the Supreme Court has basically said, maybe you're not a citizen in the way that we've understood you to be a citizen for 200 years. Who has time for a Hatch Act violation when there has been the conveyance of U.S. Marines to L.A. And National Guard without the blessing of the governor of the state that you're sending the National Guard to? So it's part of the overwhelming of the system and the the flooding of the zone, as they say. It's a terrible thing, but it falls a little bit by the wayside because there's so many other dire existential things that are going on, which is not an excuse for it. And the worst legacy of all of this, in some ways, is that people will not trust and respect independent, impartial decisions made by individual prosecutors at the Justice Department, because now in recent history, there have been demonstrably political actions, weaponization, and the Orwellian, and it's even worse than that, because it's not just the weaponization of the Justice Department, it's the weaponization of the Justice Department following claimed weaponization by the other side and taking, for example, the most partisan, unqualified, disastrous interim U.S. Attorney Ed Martin in the District of Columbia. And because he had no chance of succeeding in his nomination for U.S. Attorney, even with a majority Republican Senate, that's saying something.
That's saying a lot.
That guy, who was a disaster, you put him in charge of the anti-weaponization division, or whatever you want to call it, section of the Justice Department. I think it's an unmitigated disaster, and it's going to take a long time to get out of it. I think a longer time than it took us to get out of the miasma that was Watergate.
Yeah, it's interesting.
What do you think about that? And then we'll go.
Yeah, I think that's exactly right. The thing that it's interesting, both you and Dan Goldman, who people that don't know, he's a congressman from New York, also a former federal prosecutor, that the two of you both mentioned that did not come, that, is because you guys are experts in this, that I hope everyone listening to this pays attention to, is it will actually make the job of line prosecutors harder.
Yeah.
Because the claims of politicization will now be echoing in the background.
Yeah.
So when prosecutors are doing the right thing, people will think, well, maybe they're doing it for the wrong reasons, even though they're not. So it's actually complicating the job, not just of future political appointees, but actually making the job of the non-political folks that much harder.
It's a complete and total eradication of neutral principles. It's not the Trump manifesto and cynical achievement is not the elevation of conservative principles or conservative results or some conservative ideology. It's the erasure of all of it, right? Because none of it means anything, right? So there are no neutral principles anymore. What is a violent protest? That's
right.
not a conservative. To Trump, depends on who's doing the protesting.
Right.
Right. If it's January 6th folks who are beating in the heads of police officers, then it's tourism. And if it's folks protesting deportations in Los Angeles, then it's an insurrection. And people buy into that. And people buy into results as opposed to process or principle. And that is a general debasement of civic understanding, and I think principles of government in this country that is underappreciated and is going to be a big problem for us for a long time.
Yeah.
On that positive note, say something positive, then we'll go.
Look, I mean, I think that the biggest thing I can say that's positive is don't let the cynics win. Everyone listening to this, like it is fashionable to be fatalist. It is sort of exciting in some respects to engage in sort of cool cynicism, but don't do it, because that's what Donald Trump wants you to think, that there's nothing you can do. Donald Trump wants you to believe your protests are futile, they don't matter, that calling members of Congress don't matter, that the courts can't stop him. Like, he just wants you to give up. And so the most positive thing I can say to you is he's wrong, and don't give him that power. Like, continue to speak out, continue to use your voice, speak out in your own way. This is something amazing that Preet and I are doing. I don't know, I was going to say 5 years ago, 10 years ago, Preet and I were sitting around in dingy conference rooms in the Capitol together, and there was nobody to listen. And now there are all these people who listen to his podcast, who subscribe to Democracy Docket, who watch things like this on Substack. And, you all, I'm seeing from your action, feel like we're making a difference. Well, my message to you is you will make a difference too. Like, you all will make a difference, and use your town square in the same way that Preet does. He's got an enormously successful podcast, but you know what? It started with Preet talking to a friend and another friend and a group of people around a dinner table, and people who would listen, and then it grew to something large. Same thing with Democracy Docket that I created, but every one of us plays a part here. And so the most optimistic thing I can say is that all of you have the power to make real difference and real change here, so use it.
Yeah. Great. And finally, Marc, true or false that you have a tattoo? and the tattoo reads, "Don't bend the knee."
No tattoo, but we never bend a knee. We stand tall.
Thanks, everybody, for joining. Follow Marc. Very important stuff. Thanks, everybody. Thanks, Marc, so much.
Thanks.